Hello, ladies and gentlemen. My name is Grishon Ngangaduo from Pcea Kinoo Parish. This week, the church is celebrating Jprc week, that is Justice, Peace, Reconciliation, and Creation Week. And our theme for this year is One Nation, One People. Now, we cannot have peace if we have unresolved conflicts. Therefore, today we would like to discuss conflict resolution in families and in communities. So what is conflict resolution? Conflict resolution is the formal or informal process that two or more parties use to find a solution to their dispute. Now, there are various mechanisms of resolving a conflict. For example, we can start with the most formal one, and that is litigation. Litigation basically is going to court. We have other less formal mechanisms, and usually called alternative dispute resolution mechanisms. These include negotiations, conciliation, mediation, traditional dispute resolution mechanisms, and arbitration. Today, I want to encourage each and every one of us to give consideration to alternative dispute resolution, ADR. Before going to court, kindly consider these alternative mechanisms. For example, in the arena of family disputes, we have inheritance disputes, and these are easily solved through ADR instead of going to court. We have separation disputes, disputes about matrimonial property, that is, property acquired during the subsistence of a marriage. We have disputes about child custody and maintenance. And the truth of the matter is, some of these disputes are so easy to resolve under ADR and can be difficult to resolve when one goes to court. Why, for example, would anybody imagine that a judge would be better suited to resolve a child custody and maintenance dispute? Why would a judge who has not seen the children, who does not know them, resolve the dispute better than the parents who have given birth to the child, who have lived with the child under the same roof, who have bonded for several years? Why can't the two parents discuss, negotiate, and resolve the dispute without involving a judge? We have commercial disputes. They can also be resolved without going to court. Then we have community disputes and even disputes involving countries generally, or even the governed and those who govern. You know, we may imagine that in this country of Kenya, we may imagine that we have very complex issues. But believe you me, if we can sit together, it is possible to resolve these disputes out of court and in a harmonious way. May I give an example of a neighboring country of ours called Rwanda? This country went through a genocide. Almost 1 million people killed in a period of a few days. But they came out of that traumatic experience through alternative dispute resolution, partly. And they had their own traditional courts called Gashasha. And these courts were able to help that country to emerge from the genocide. They helped them in communal healing, in rebuilding. So we can also try that in our country. We can sit together and find solutions to the disputes that bedevil this country. By the way, if you look at the history of ADR, you will realize that we as Africans and as Kenyans have always practiced alternative dispute resolution. Way before colonialism brought us courts and judges and lawyers and prisons and police, way before that, we used to have conflicts and we actually used to resolve them through our elders and other traditional mechanisms. And I want to submit that even now, those methods of resolving disputes can still be used. In fact, our own Constitution of Kenya 2010 has given prominence to these alternative dispute resolution mechanisms. If you look at Article 159, sub-article 2D of the Constitution, it actually promotes alternative dispute resolution mechanisms, including conciliation, mediation, reconciliation, arbitration, and traditional dispute resolution mechanisms. Let us look at who can help us in conflict resolution. Number one, it is our families. For example, if spouses are having a conflict, why can't they involve their families? Before they go to court, why can't they go to their parents on both sides? We can also resort to our relatives. We may have respected relatives or influential members of the family, and we can make use of them. We can also make use of elders in our community. We can make use of our administrators, like the local chiefs. We can also make use of religious leaders, such as pastors. Allow me to dwell a bit on one dispute resolution mechanism, which is mediation. So mediation is a process of dispute resolution where a neutral third party, usually called a mediator, helps two or more parties in conflict to reach a mutually satisfactory agreement. It is used to resolve a wide range of disputes, including commercial disputes, family disputes, and even community disputes. The mediator does not make decisions or impose solutions, but instead, he helps the parties to identify the issues in dispute, to explore options, and to find common ground. If parties agree after mediation, they then sign an agreement, and that agreement is legally binding and can be enforced in court if necessary. Mediation can be private or it can be court annexed. In other words, the two parties in dispute can decide to engage in mediation. They can choose an arbitrator without the involvement of the court. But also, these days our courts refer some disputes to mediation, in which case it becomes a court-annexed mediation. Now, let us look at the advantages of mediation as compared to litigation. Number one, mediation is cheaper. Secondly, mediation is faster. Most of the mediations I have seen, they just take 2 or 3 meetings, perhaps in a span of a fortnight, and the dispute is resolved. Number 3, mediation is confidential. What gets said in the mediation room remains in the mediation room. On the other hand, the court process is completely public except for very limited circumstances. Number 4, the parties to mediation are in control of the process. Number 5, mediation is flexible. It can be done at any time, at any place, depending on what suits the parties. It can be done in the sitting room. It can be done under a tree. It can be done on the beach, anywhere that parties find necessary. Number 6, mediation takes care of emotional aspects. Mediation allows parties to pour out their heart, to express their feelings. If they are hurt, they say they are hurt. If they are in pain, they say they are in pain. That never happens in court. In court, it's about the evidence and the law. You bring the facts and the evidence together and check whether they square against each other. There is no room for feelings, no room for emotions, no room for lengthy explanations. The other one, and this is perhaps the most important advantage, mediation preserves relationships. In other words, after parties have engaged in mediation, chances are very high that they will arrive at a solution and then they will shake hands, hug each other, and move on with life. If they were in business, they are likely to engage in another business deal, perhaps the same day or in the following few days. If they are family members, they are likely to live in harmony going forward. That rarely happens in court. Lastly, the parties own their outcome, hence ease of enforcement. Because parties in mediation decide what the solution is, therefore, it is very easy for them to abide by that solution. If you try that in court, whatever solution the court gives, you may need the assistance of prison or jail or auctioneers or other coercive means to force a party to honor the outcome of the court process. So then, what is my parting shot? My parting shot is litigation is a measure of last resort. Go to court if you must, but do not be in a hurry to go to court. Consider the alternatives. And finally, allow me to leave you with this Bible verse. Matthew chapter 5 verse 9. The Bible says, "Blessed are the peacemakers, for they will be called children of God." Do you want to be called a child of God? Be a peacemaker. And one way of being a peacemaker is promoting alternative dispute resolution mechanism. Thank you, and God bless you.